Following along with the Karmelo Anthony motion for a new trial hearings today, and the reporter inside the courtroom is reporting what's being said.
This is Legal View, where we look at the news from a legal point of view.
And the defense started out, they went first and talked about the constitutional violations that are outlined in their motion. Prosecutor Bill Werschke has gotten up, or he's actually finished now, but he starts talking about the actual guilt or innocence of Karmelo Anthony. Now, that's not really at issue here. The issue is, were his constitutional rights violated? I've said that many, many times. Many of you always jump into the comments and talk about, oh, he's guilty, he's guilty, he's guilty. Fine, whatever he's guilty of is not the problem here. The problem is, was the trial fair and were his constitutional rights violated? But Bill Werschke wants to say, and I'll tell you some of the things he's saying. It's going to make some of you critics very happy. And again, I'm not sure what this has to do with whether he was guilty of this particular crime or if this was self-defense or anything, or less than, let's say, manslaughter or criminally negligent homicide. But anyway, he's talking about, he's telling the judge, the new judge, Anthony's high school girlfriend told an assistant principal at Frisco Centennial High School that they had broken up and that Anthony was stalking her. Werschke goes on to say the deadly stabbing of Austin Metcalf happened a few hours later. Werschke claimed Anthony was obsessed with fights, guns, and knives. And we knew that. We knew from the motion for a new trial and the affidavit filed by Mike Howard that all this information they had on Karmelo Anthony really did focus in a lot on his obsession with violence or fighting and guns and knives. I don't know if that's very different than a lot of teens, but as I've said many times, when it's a black teen, sometimes it can be looked at a little differently. I don't know anything about those pictures, so I have to wait to see those. The district attorney goes on to argue that Anthony's self-defense argument would not have held up in court. And again, this is not a hearing about guilt or innocence or whether his arguments would have held up in court or not. The problem is he never got a chance to make his arguments because of a deal you made and the fact that you cut him off from testifying because of your interpretation of a deal that you made with the defense. So again, we can talk about Karmelo Anthony, what he's done, what he didn't do, and that's never been the issue here. And I think the problem here in terms of how people see this is not that people who think he got a raw deal here say that he's not guilty of something. The question is he never actually got to put on a defense. And I just wish people had more of an opportunity or more of an ability to put themselves in the shoes of, let's say your own child was on trial and never got a chance to put on a defense because of some deal that was done that affected his constitutional rights. You would want these same things. Now I say, let's have a fair trial. According to the rules of evidence, what evidence can come in against the victims, what evidence can come in against Karmelo Anthony. If we want to know about this, situation with his girlfriend, let's get it in if that's something that will be allowed under the law in Texas, and then let the jury decide from there. Let Karmelo tell his story. If that's what the attorneys decide is the best way to go, and let's have a fair trial. And then if he's convicted of murder, that's fine. That's fine. Let's try to work it out so that we have a jury of his peers. I'm not saying force black people onto the jury, but don't kick off black people who say that they can be fair and impartial. And I truly believe this whole education, they were educators in the system, disqualify them from being on a jury. You can say whatever you want. And I don't think that's going to fly in this new trial motion because it's hard to compare. What the test is you compare other jurors that were chosen in the case to see if there was some disparate treatment to the black jurors. And people are arguing that there was an educator on the jury. That educator worked at a beauty school. I'm not sure those are two things that can be conflated with each other. But again, I also don't think that you can conflate the fact that they were teachers with the fact that they couldn't be fair and impartial. And I will say Texas has a history, a written history, recent history, early 2000s, late 1900s, 1990s into 2010 or so. They actually had rules. They had whistleblowers who came forward and said, we had rules on how to get rid of black jurors, the things to say that would allow you to get rid of them without being double checked or that would pass muster. So it's a tradition in the courts in Dallas to try black defendants, if possible, without black jurors. So these are legitimate concerns when you see the last three women who all say they could be fair and impartial removed by the prosecutor. I'm not saying that's what he did. I'm not saying it's not going to pass constitutional muster. It's not a very difficult test, but it is a concern, and I think it's fair for people to be concerned about it. So again, these arguments are being made, and I will remind you, there is a very tight deadline here. This new judge has to get fully and utterly up to speed on this case. I don't know how he does that in 3 days, but August 24th is the deadline according to a 75-day deadline according to statute in Texas, that you have 75 days from when sentence is pronounced to rule on these post-trial or post-conviction motions. That's Monday. So this new judge has to come in, get fully up to speed on the record, listen to these arguments, get up to speed on the arguments in terms of the motions, etc., and then rule on this by Monday. Here's the other thing. He doesn't have to do anything. Because under the law, if nothing happens to this motion, if he doesn't rule, then it just goes on up to the Court of Appeals. And these arguments made in this motion for a new trial are preserved for appeal at that point. That's the whole reason you make these arguments at this time, this post-trial conviction motions, is anything that wasn't objected to during the regular trial, you make a record of it here, and that preserves it so that it can be argued during the appeals phase. So they don't really have to do anything. So we'll see what happens. I don't know how someone can step in this late and provide a full picture or get a full understanding of the full picture and make a ruling like this, such an important ruling. But again, as I've said, these are low percentage motions, and so are the appeals. But again, you have to give it the old college try. And I think this one, again, just like I said about the motion to recuse, which is granted much more often than motions for a new trial, obviously. But I also said I thought there were some really important and issues that needed to be litigated in this motion for a new trial that may not make it past this stage, but I think on appeal, at the appeals level, the appeals court level, could sway a judge or two. But we'll have to see on that. All right, I'm Michael Ayala, and this is Legal View.
Legal View, where we view the news through the lens of the law.